Joel's the lope. You want the bill, and then all the elders there at the corner, the senior elders of this country. Genesis, eh? Thank you so much. Honorable, would you want to tell us why you want to withdraw your bill?
Right, Honorable Speaker. That bill, as you recall, was tabled here for the first reading, then it went to the committee. But in the course of the interaction with the committee and within our own consultations, we found that there are things that need to be aligned within the bill itself, but also which, if done, would substantially change it. So, and the only recourse was to request that it be withdrawn and then brought back for reconsideration.
Thank you so much. Honorable members, I now put a question that the Forensic Evidence Bill 2024 be withdrawn from the House. Those in favor say aye, and the contrary nay. The ayes have it. Honorable members, the Forensic Evidence Bill 2024 stands withdrawn. Thank you.
Item 3 on the order paper, laying of reports by the Leader of the Opposition in Parliament pursuant to Rule 35 of the Rules of Procedure.
Honorable members, yesterday I guided that the Leader of Opposition would table copies of his oversight reports for onward referral, and that is pursuant to Rule 35 of Rules of Procedure, and we would refer them to the relevant committees. I will now invite the Leader of Opposition, Honorable Joel Senyonyi, to come and lay the reports. Kindly read for us the report for which institution, then you lay different reports.
Thank you, Right Honorable Speaker. Honorable Speaker, I would like to lay a couple of reports, which brief reports I have read here, but it's good that there is follow-up, and as you guided, they'll be sent to relevant committees. The first report is an oversight report to Atiak Sugar Factory. That's the one that's so far been given 553 billion shillings. I beg to lay.
Thank you, please lay.
The second report is about an oversight visit I carried out together with shadow ministers today Biopharma Limited in Matuga, Wakiso district. That's the one that has so far been given 723 billion shillings. I beg to lay.
Thank you.
The third report was about an oversight visit to Rocco Construction Company. That's the one that has been given so far 263 billion shillings. I beg to lay.
Thank you.
The other report is about an oversight visit to Inspire Africa Coffee Factory in Tungamo district, which I read yesterday. The billions given are unknown so far, and that's captured in the report. Hopefully government will have occasion to clarify. The final report for now is about an oversight visit to Busoga sub-region on the drastic fall of sugarcane prices. I beg to lay.
Thank you. You had another one. Thank you, Leader of Opposition. The reports are accordingly referred to the relevant parliamentary committees, ministries, departments and agencies for action and report back to this House. And we are giving the committees, relevant committees, because they are going to different committees. The word relevant would mean that I will guide, because I'm going to write a letter to different committees. Thank you. Next item.
Item 4 on the order paper, Bill's second reading, the Occupational Safety and Health Amendment Bill 2023.
Honorable Minister of Gender, Labor and Social Development, would you move a motion?
Thank you. Right Honorable Speaker. Right Honorable Speaker and members, the Occupational Safety and Health Amendment Bill 2023 was read for the first time on the 9th January 2024, and this was referred to the Committee of Gender, Labor and Social Development in accordance with the Rule 129, subsection 1 of the Rules of Procedures of Parliament. The bill before you was drafted within the approved policy context of employment, namely the Third National Development Plan 3. Through the Human Capital Development Program, objectives of improving population health, safety, and management in order to reduce workplace injuries, incidents, and health hazard.
Honorable Minister, first move a motion, then you will give us the justification. First move a motion yourself, then you'll give us a justification. You're moving a motion for the second reading of...
Right Honorable Speaker, we're moving the motion for the second reading.
Of what? Say the name of the bill.
Right Honorable Speaker, the motion is Occupational Safety and Health Amendment Bill 2023, and it's read for the second time.
Honorable members, the Minister is moving a motion for the second reading of Occupational Safety and Health Amendment Bill 2023. That is the motion that the Minister is reading. Is it seconded? Is it seconded? Seconded by Obama, by Emmanuel, by the whole side on this side, by Attorney General, by Honorable Kania, Honorable David, former CDF, by Honorable Echeru, Honorable Kaduchu, Prime Minister, the whole house, the Kabanda, Alanyo, Nekesa, by the whole house. Would you now justify your motion?
Right Honorable Speaker and honorable members.
Honorable members, can I have your attention? You think it is easy to stand there and speak? Yes.
Right Honorable Speaker, let me stand up properly. Right Honorable Speaker and honorable members, the Occupational Safety and Health Amendment Bill 2023 was read for the first time on the 9th of January 2024 and referred to the Committee of Gender, Labor and Social Development in accordance to the Rules 129, subsection 1 of the Rules of Procedures of Parliament. The bill before you was drafted within the approved policy context on employment, namely the Third National Development Plan 3, through the Human Capital Development Program, objective of improving population health, safety, and management. In order to reduce workplace injuries, incidents, and health hazard, as well as the proposed national employment policy. Fourth objective, to promote safety and health working environment. Honorable Speaker, honorable members, The OSH Amendment Bill is intended to address the prevailing challenges registered under the current law on occupational safety and health. The Occupational Safety and Health Amendment Bill 2023 seeks to address the challenges and gaps through the 5 principles, which include: 1, providing a clear process and responsibility for prosecution of offenders in courts of law. Expand the scope of the law to cater for all workplaces. Streamline powers of the ministers responsible for labor to make regulations. Remove inconsistency from the law and harmonize with other laws. Right Honorable Speaker, honorable members, since the approval of the principle of this bill in November 2021 and the first reading of the bill on the 9th of January 2024, consultations have been conducted with various stakeholders through the collective effort of Gender, Labor and Social Minister of Gender, Labor and Social Development Committee of Parliament, the Attorney General and various stakeholders. The bill has since been processed. Right Honorable Speaker, I would like therefore to invite you to pass the OSH Amendment Bill 2023. I thank you.
Thank you so much. I now invite the chairperson of the Committee of Gender, Labor and Social Development to present the committee report on the bill.
Thank you, Right Honorable Speaker. I'm here to present the report of the Committee on Gender, Labor and Social Development on the Occupation Safety and Health Amendment Bill 2023. I beg to lay the documents on table. I beg to lay the report of the committee.
Please lay.
I beg to lay the report on the benchmarking meeting of the committee. I also beg to lay the minutes of the committee while processing the bill. Right Honorable Speaker, the Occupational Safety and Health Amendment Bill 2023 was read for the first time on 9th January 2024 and referred to the Committee on Gender, Labor and Social Development in accordance with Rule 1291 of the Rules of Procedure of Parliament. The committee scrutinized the bill in accordance with Rules 129, 2, 3, and 4 of the Rules of the Procedure and now ready to report.
Thank you.
Right Honorable Speaker, I would like also to clarify on some issue. Allow me to clarify that the Occupational Safety and Health Amendment Bill 2023 was tabled for the first reading, drafted following the old edition of laws of Uganda, that is the 6th edition, Occupational Safety and Health Act 206. The laws have since been revised. The committee processed the bill as tabled to enable proper flow while considering the amendment on the floor. On that note, Right Honorable Speaker, the provisions of the bill will be revised with the correct references in line with Section 82 of the Acts of Parliament Act, as per the revised OSH Act, Cap 2317 7th edition. Right Honorable Speaker, allow me to skip some of the areas like the background, because the minister has already highlighted the intention of the bill. I will skip the objective of the bill, the defects, and how the bill is addressing the defects. On page 5, Right Honorable Speaker, we are looking at the methodology, and one of the methodology was the meetings.
Yes, procedure matter.
Thank you, Right Honourable Speaker. Right
Before you
Honourable-
raise your procedure, in the public gallery this afternoon we have a group of student leaders from the Guild Representative Council of Makerere University. They are represented by Honorable Kazibwe Bashir Mbazira and Honorable Malende Shamim. You're most welcome. Where are you? Students, where are you? Stand up. You're most welcome. Join me in welcoming them. Welcome to your parliament. They are here to observe the proceedings of this house. You're most welcome. Thank you for coming to your house. Thank you. In the public gallery this afternoon, we have a group of students from Madi sub-region, which include Obongi, Moyo, Ajuman, under the Madi Students Union. They are represented by Honorable Alero Tom Aza, Honorable Ababiku Jessica, Honorable Mamawi James, and they are here to witness the proceedings of this house. Thank you. Please stand up and we see you. Thank you. Thank you so much for coming. You're most welcome. Yes, procedure matter.
Thank you, Right Honourable
I'll
Speaker.
give you time and you greet them.
Right Honourable Speaker, we appreciate the communication of the Minister and the Chair. But Right Honourable Speaker, the Chair has said that the Minister highlighted, so she's skipping the defects. Yet the bill, the whole story about that bill is the defects. Because as we are listening, we must know the defects that informed the bill and whether the bill has addressed the defects. So we through your office, Right Honourable Speaker, would it be procedure right for the Chair to tell us the defects that caused the bill to be tabled? Then we listen and see whether they have cured the defects. Thank you.
Honorable member, what the chair was saying, the minister had already talked about the objects of the bill, the defects of the bill. You had her reading. I think you're not yet here. You have just come. The minister read the defects of the bill, and the report is here. If, Yeah, it is the minister's problem that she's trying. It is not. You continue.
Thank you, Right Honourable Speaker. The defects are copied from the bill as it is presented before Parliament.
Don't waste your time. You go ahead.
Okay. Right Honourable Speaker, I was on page 5 and I was giving the methodology. As you can see on that page, the meetings, the stakeholders are highlighted. We reviewed some documents, they are also highlighted. We had some field visits, some 3 companies, they are listed there. Then we had a benchmarking visit. The committee sent a delegation for benchmarking visit to Nairobi, Kenya, coordinated by Kenya Central Organization of Trade Unions. The delegation held meetings with staff.
Honorable Chair, the methodology, the meetings you had with the Minister of Gender, Labor and Social Development, Office of Attorney General, Federation of Uganda, it doesn't cost you much to tell us whom you met.
Thank you, Right Honourable Speaker. The committee met with and received written memoranda from the following: Ministry of Gender, Labor and Social Development, Office of the Attorney General, Federation of Uganda Employers, Central Organization of Free Trade Unions, National Organizations of Trade Unions, Platform for Labor Action, Uganda Small Scale Industries Association, Safety and Health Association of Uganda. Then we also met Dr. Ekwaro Ebuku as an individual. 6.2, we reviewed the documents, the Constitution of the Republic of Uganda, the Occupational Safety and Health Act 206, the ILO Convention 155. We also had a field visit. We visited Land Industries Uganda, Saino Uganda, Mbali Industrial Park, Tembo Steel, Uganda Limited. We also had a benchmarking visit. The committee sent a delegation for benchmarking visit to Nairobi, Kenya, coordinated by Kenya Central Organizations of Trade. The delegation held meetings with staff of the Directorate of Occupational Safety and Health Services, Ministry of Gender and Social Protection. The report has been laid on table. General observations and recommendations. Limited scope of the bill in addressing the defects in the current OSH law. The committee observed that whereas according to the memorandum of the bill, the intention of the bill is to expand the scope of the application of the OSH law and provide for the changes at the workplace arising from the new dynamics and rapidly evolving sectors such as telecommunication and extractive industry, the bill does not effectively address this defect. For instance, the committee observed that the submissions of the Ministry of Gender, Labor and Social Development, Federation of Uganda Employment, Uganda National Association of the Community and Occupational Health, that whereas the bill sought to provide a proposal on the new changes arising at the workplace from the new work dynamics, like new hazards in the telecommunications and extractive industries, the bill did not provide for internationally recognized OSH standards and practices like the obligations of an employer to carry out safety and health risk assessment and health surveillance plans which evaluate health-related hazards and the workplace and monitor the safety of the health of workers and health of workers. Secondly, Ministry of Gender, Labor, Social Development and Uganda Small Scale Industries informed the committee of the need to regulate OSH practitioners who are currently not being licensed under any law, and as a result, there is lack of standardization of OSH assessments and reports done at the workplaces. In addition, the Federation of Uganda Employers noted that the current provision of the first aid were archaic and did not provide for internationally recognized practices like an employer to put in place a first aid assessment plan. The committee recommends that the additional proposals should be adopted to form part of the bill so as to enrich the intention of the bill. Compliance with occupational safety and health standards by enterprises. The committee carried out assessment of occupational safety health status in selected factories during the consideration of the bill and observed that whereas certain workplaces had put in place safety and health measures for their workers, in others there were still gaps that needed to be addressed. The committee recommends that the Ministry of Gender, Labor and Social Development regularly follows up on issues of compliance and effective implementation of occupational safety and health laws and measures in all workplaces. Absence of occupational health services for employees at workplace. The committee observed that the current law does not have provisions obligating the employer to provide occupational health services for his or her workers, like counseling, body fitness activities, stress management aimed at their wellness and mental health management. In many workplaces, long working hours and demanding job responsibilities have become the norm. The pressure to meet targets and the fear of job insecurity creates an environment that fosters stress and anxiety in the workers, which can contribute to unhealthy lifestyles and mental health challenges. The committee recommends that the amendment in the bill, which seeks to impose an obligation on the employer to provide occupational health services aimed at protecting the wellness of the workers at the workplace, be adopted. Delayed operationalization of Occupational Safety and Health Board. The committee noted that Section 10 of OSH Act establishes the Occupational Safety and Health Board, which is to give expert advice to the minister on matters concerning occupational safety and health and welfare at the working environment. However, 18 years later, the board has never been operationalized, which has resulted in difficulties to execute key policy formulation. The delegation to Kenya, while on benchmarking visit, observed that Ministry of Labour and Social Protection, under its Directorate of Occupational Safety and Health Services, has a fully-fledged training institution on OSH, that is the National Institute of Occupational Safety and Health. Its mandate is awareness creation on OSH, training of workers and employers in safety and health, and carrying out research on matters relating occupational and safety health. It was also further noted that Kenya has an established National Council for OSH, which functions is to advise Cabinet Secretary on OSH policy matter, best practices on OSH, among others. The committee therefore recommends that Ministry of Gender, Labour and Social Development should fast track the operationalization of Occupational Safety and Health Board. OSH management information regarding numbers of OSH inspectors. According to OSH Management Information System, a database developed by Ministry of Gender, Labour and Social Development, there are 21 government OSH inspectors, compared to the many registered workplaces estimated to be over 8,000. According to Ministry of Gender, Labour and Social Development, in 2024 alone, 1,572 workplaces were registered. Therefore, the ratio of 21 officers to 8,000 workplaces is at 380 each individual, which is a heavy workload on the OSH department in Ministry of Gender, Labour and Social Development. This kind of trajectory has led to delay in service delivery, non-compliance to OSH standards by many of the employers. The committee recommends that Ministry of Gender, Labour and Social Development should recruit OSH officers who should be evenly distributed across the district to ensure effective implementation of OSH laws and measures in workplaces. Unregulated private occupational safety and health practitioners. The committee noted that currently there is a large number of private OSH practitioners who are carrying out OSH inspections and audits in the workplaces. The private OSH practitioners are unregulated due to the absence of an enabling regulatory framework, and this has led to many people carrying out OSH work that is unchecked, hence compromising OSH standards and practices and greatly exposing the workers to hazards. The committee recommends that the proposal on regulation and licensing of OSH practitioners be adopted. Right Honorable Speaker, under 8.0, there are specific observation. We are looking at the clause by clause. I don't know if it will not take a lot of time or we should go direct to the clauses. If you allow, I can read.
Thank you. No. She's now going to committee stage. She has finished reading the report. You want her to read to go to committee stage?
Right Honorable Speaker, at the report there is specific observations and recommendations, but they touch on the amendments. For reading them would mean doing it in a double way because there is already one.
Ethel?
Let me conclude on the report. In conclusion, Right Honorable Speaker, currently there is a big workforce due to high economic growth, increased industrial developments, and new technologies in the country. This has also led to an increased new risks, challenges, hazards that affect the safety and health of workers at the workplaces. The amendment of the current Occupational Safety and Health 206 seeks to strengthen safety and health measures and expand the application of the law. The committee recommends that the Occupational Safety and Health Amendment Bill 2023 be passed into law subject to the following proposed amendments. Right Honorable Speaker, I beg to report.
Thank you, thank you. Honorable members, Honorable Isha, I'm going to allow you. When somebody is reading a report and we interrupt, it distorts what comes out of unanswered. So it is always good to allow somebody finish, then you bring the procedural matter. So that when it is somebody out there who is reading, he reads in a way that it flows. Yes, procedural matter.
Thank you so much, Right Honorable Speaker. The way the report is being read, she skipped very critical issues. Because when you go to committee stage, she will only be reading the amendments and her justification. She will not tell us the observations made. It's so important to us that the observations they made, they come to record. They help us get an understanding of what they found in the field when they went out there. So it is very important that we go through them so that it doesn't bog down the debate when you go to committee stage, or we don't pass things that will not have very well understood. I pray that she goes through the observations on those particular clauses where she recommends amendments. Thank you.
Do you have a report with you?
Yes, I do have the report.
Please, just check. Let's go together. 8.1. Yes, Ether.
Thank you so much, Madam Speaker. Madam Speaker, I move that, having received the report, we first make some inputs on what we would wish to be clarified on. Then later on, we get to committee stage, and that's where we shall be now getting close to close, asking for clarification on that matter. But there are some general inquiries we would wish to move. So my motion is that the House first
debate
get some
the
clarity
report
over some matters of the report, and we inquire from the minister.
What
Proceed.
Hajat is saying, we should also look at the recommendations that have been made clause by clause. That's what Hajat wants. Yes, Kumi.
Right Honorable Speaker, now that this is an amendment bill, normally, in my view, it's very, very important that we go through the entire report. Because you might find that some of the issues are highly controversial, and people need to understand them, and that is exactly what brings out the debate. Because we must fix what we want to fix here. By the time we go for committee stage, we are simply passing what we have already agreed on. My view is that it will be proper that she completes the entire report, we understand it, so that we pass what we know. Committee stage, we may not have the time, because we shall be reading out the clauses one by one, and we shall pass what we may not understand a lot. Thank you.
Jonah? Jonah, not Jonathan.
Madam Speaker,
Hey.
the report is in our iPads. we have read the report. If we have anything to amend or to change, we go through the iPads.
He's called Jonathan also. He's called Jonah also.
Aisha, I'm called Jonah. Jonathan is here.
Jonathan? Honorable members, we have the report here, and the report is the report that the committee gives is basically to inform the debate. It is not part of the amendments. That's what the report. That's why the report is telling you we visit so and so, so and so, so and so, and it is not telling you that it is because we visit so and so. That's why we are making an amendment in clause A, B, C, D. So I would think let's bring your ideas on the report that she has given, and then we look at clause by clause. Attorney General, what do you think?
Right, Honorable, I'm in agreement with your guidance.
Thank you.
Thank you so much, Madam Speaker. Madam Speaker, as we are discussing the report, could we know from the Minister where is she getting the challenge to operationalize the Occupational Safety and Health Board, because it's one of the gaps we are seeing in this matter? Thank you.
Thank you. Yes, Isaac.
Thank you, Madam Speaker. Madam Speaker, as we discussed the report, we would also like to know what was the committee's input in terms of mandatory trainings for the workers, because in this health occupational hazard, we cannot only point fingers at the employers, but I feel like the workers also must comply with mandatory annual trainings, so that in case of any form that anything goes in court for compensation, that will be the first area to check whether there was annual. And the report does not cover on that area the compulsoriness in terms of the employees' awareness.
Thank you. Minister, take notes of what is being asked. Jessica.
Thank you, Right Honourable Speaker, for the opportunity. I need clarity on one of the key issues raised in the report, that is the non-operationalization of the board. And yet we have just concluded our decision on rationalization. So I'll wish to know the effect of rationalization on the comment of the committee on the operationalization of the board. Thank you.
Thank you. Butambala.
Thank you, Honorable Speaker. One of the biggest defects of the law, existing law, is that it didn't give due consideration to people that work from homes. I want to know in the proposal that we have, because you know, over time you're now popularizing cottage industries, people working from home, and even people that serve us. Does the report and the proposed amendments take into consideration people that have get occupational hazards while working from our respective homes?
Thank you. Lillian, then Silo.
Thank you, Right Honourable Speaker. I would like to seek clarification from the Chair on the unregulated private occupational practitioners. Right Honourable Speaker, I came across a private occupational practitioner assessing in a small private business that I have. They came with a letter purportedly to have been given by Ministry of Gender. So I wanted to understand who mandates these people to go and do the assessment. And my thinking was they report back to the ministry. So for me, this caught my attention, so I wanted to understand who pre-qualifies these people, and now that the report is saying that they are not regulated. Thank you.
Thank you.
Right Honorable, just yesterday but one, a retired army officer, okay, private, I don't know whether they also called officers, came to me in the constituency and reported the suffering that he went through when they had been mobilized to go for national duty in Somalia. And the truck rolled along the way.
Honorable, both. And
the person nearly lost his
You
arm.
first start from where?
Just yesterday but one. A retired UPF officer who told me his story that he was recalled back to service and they were meant to go to Somalia between 2020 and 2022. Unfortunately, along the Tirinyi Road, the truck got an accident. Many of them got injured. He was unfortunate because his arm got under the truck which was rolling on the tarmac, and it was nearly cut off. But by God's grace, doctors managed the situation. Today, he cannot even lift a cup of water using that what? Hand. This man was given 3 million shillings. But remember, 3 million shillings. He can no longer do any work that is meaningful. And I have his document that I'm going to submit to you after this. Right Honorable Speaker, the real issue that I want to bring out is that in this report, I have not heard from the committee as to how many of these people who suffer these injustices of occupational nature that you heard from. Because they are the ones who can tell you the real story. How many of them came before this committee so that they tell you the real suffering that they have gone through? I have also heard from a young girl who worked in the industrial area. She said that for her, they have decided now to lock her out. The Indians do not want to see her within their premises. Did you hear from such people? So that they give you the real story that helps you to inform what we need to do in this law. I now want to say, one, Right Honorable Speaker, we need to see how we can put in this law the aspect of ensuring that entities provide the budgets for health and occupational safety, and it has to come through the law. That will be a good thing. Number two, the issue of recruitment should be a command that comes through the law. We are not just going to recommend to the Ministry of Gender, but it should be planted in the law. If we are saying that every district should recruit, and I guess this is a government bill. If it's not a government bill, let government allow that we should recruit people who are going to do this. And what are the functions of the board, the one which is doing the occupational safety work? We should be able to do audits to see whether people are not flouting what is in the law, so that those who are flouting the law, we withdraw their certificates.
First of all, have you established that there is a board? The law that was done previously, I don't know what could have happened. It said the minister shall establish the board. It did not give, through regulations, it did not give the number of the board members, and the regulations were never brought to this house.
So, Right Honorable Speaker, those are some of the audits that this house should do. Actually, because that's our oversight work, some people now need to be arrested for failing to do what they are supposed to be doing. If you were supposed to establish a board, why did you fail to do that? Because that is the life of the citizens of this country. They need to survive. Somebody needs to be their voice. And if you are given work and you are not going to do it, there are many members of parliament here who can be ministers. Why are they not recruiting them to those positions? Yes, so, yes, even me myself,
Honorable Silo, instead of thinking of arresting ministers or whichever, in the rules that we are making, that we are going to go to after here, we have a provision where we are going to have subsidiary regulations. We will have a committee on subsidiary regulations that shall follow on the rules, on the laws that we have passed.
I think, Right Honorable Speaker, you would have given a New Year's gift to this country if we do that, because it will solve many, many problems. I'll be welcoming information after one submission yet.
But you're taking a lot of time.
The last one, because my interest is actually this subject. That's why I'm taking a long time, Right Honorable Speaker. When I look at the issue of the entities that are stubborn in terms of compensation, we must be able to input a section here which provides that if an entity does not comply with the requirements of the law regarding the occupational safety and work, then that person, that entity, they should revoke the license. That will put them in tenterhooks to deliver. Let me take the information from my sisters, starting from you. And then
Honorable Kavanda, then Honorable Workers.
Thank you.
Honorable Baka, after Honorable Kavanda.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the information I wanted to give to Honorable Sairo is that what we are discussing is the Occupational Safety and Health Amendment Bill. What is raising falls under Occupational Act, so and Employment Act. So it's different. We shouldn't confuse the two.
I thank you for that information.
Honorable Baka.
Right Honorable.
Honorable Baka.
Right Honorable, he was giving me the information.
Baka.
Right Honorable Speaker, and I want to thank my colleagues for that concern. As he has rightly said, we are concerned with occupational safety and health. There is Workmen's Compensation Act and there is Employment Act. But when we come to the committee stage where we need amendments for remedies of the employer who has not complied with occupational health and safety, you are going to hear them. I thank you for that.
Thank you. Thank you. Ntungamo.
Thank you so much, Madam Speaker. Madam Speaker, in support of the recommendation by the committee that occupational health should be incorporated in the law, I wish to remind all of us that we have employers who do not have even human resource departments, meaning that by incorporating it there, all employers will make sure they have those departments. People want counseling. People get jobs, but they end up leaving them because of several challenges. Having no such a department, someone wants a job, the employer wants an employee, but the employers cannot be retained. Yet there is competition for good talents in the whole world. You lose employees because you are not catering for them. So that will make Uganda one of the best destinations for employees, and we shall be able to maintain our talents and even attract talent from abroad. Thank you, Madam Speaker.
Thank you. Can I hear from the Minister first? Apolot.
Thank you.
Apolot, then Muvende.
Thank you so much, Right Honorable
Then
Speaker.
Tom.
Right Honorable, mine is on page 6, Roman 3, which is indicating that the recruitment agencies are only accredited and not licensed as demanded by the law. And when you look at 4.4, where the committee made recommendations, they were only concentrating on who should take the responsibility of providing the licenses to such institutions. My proposal, Right Honorable, is that since the law provides for it, any recruitment agency that does not have a license should not be allowed to carry on the duties, which is missing in the report. Thank you so much, Right Honorable.
Chair. Let me first get a chair's mind on that.
Thank you, Right Honorable Speaker. I think the Honorable has gone to the employment amendment bill. That is not part of the OSH bill. Maybe allow me to respond to some of
Honourable
the...
members, we have the employment bill and we also have the OSH. So let's not mix them. Let's first look at this.
Right Honourable, allow me to inform members that this is an amendment bill. The OSH law is very comprehensive with a lot of details, but we are handling an amendment bill which had specific areas, sections they wanted to amend, and that's why we have responded. But if you go into the OSH law, you'll find that all the details are there. And some of the issues that have been asked there, they are to do with workman's compensation. Secondly, a member also asked about that did we consult other people who have ever been affected by OSH at the workplaces, like accidents and so. You know the procedures of Parliament, Right Honourable Speaker. The fact is we advertised in the papers to call upon all members who want to submit. So we listed those who came, who responded and came. So we don't know those who are out there and have issues. Another thing which was raised is the trainings. The trainings are also provided for. That's why even workplaces have committees, joint committees of staff and management that oversee the activities concerning OSH at workplaces.
Actually, when you look at section 73, it looks at the training.
I remember also raised the issue of assessment of workplaces in a small place. We mentioned that there are some inspectors of the Ministry of Gender. However, we also mentioned that there are those private practitioners out there doing the job. That's why we're saying, because they are going to industries, they must work with the ministry, and we have made a provision, a new clause, to get them regulated so that even if they are doing their work, they are doing it in consultation with the Ministry of Gender. And another issue which has been, I think those are the areas they have touched. Yes, you talked about home workers. The law applies to every workplace. All labor laws apply to every workplace. Even if it is your maid who gets a problem, the laws cover them. They can approach any labor officer or government or anywhere. The laws apply to everybody.
Dr. Alulme.
Yeah, thank you very much, Right Honourable Speaker. The chairperson of the committee, I wanted the attention of the chairperson of the committee, whether they looked into other workspaces where there are safety or even hazards at within the occupation spaces, such as the councils, district councils, sub-county councils, where we see fights, people hitting each other, and going away with wounds. Parliament is one of these spaces.
Yes.
Yeah, while we are here in Parliament, who is responsible for us, for instance, if at all we get in trouble at work, within the councils, and so on, as the committee addressed itself on these spaces as well. Thank you.
If somebody is coming to work in most workplaces, then gets an accident, that person will be compensated under the workman's compensation. Those people are provided for. And I'm sure even at Parliament, if we got injured here, we are supposed to be taken care of. But Honorable Ulume has widened the space to people who are fighting out there, fighting against each other. Those ones become criminal issues where you need to report to police.
Thank you. Oza?
Thank you very much, Right Honourable Speaker, for the opportunity. Thank you very much, Chair. Madam Speaker, West Nile has been invaded by illegal gold miners. Others are in Metu Hills, others in Terego, others in Yumbe. And more often than not, these people do not follow occupational safety rules. no helmets, no gloves. They enter into tunnels where there's a lot of heat, and when they come out, they become sick. Still, they are not being catered for. So all this will be put into consideration. Thank you very much.
Are those people employed to do that, or they go willingly?
Right, Honorable Speaker, they are illegal. They are illegal. Those are illegal gold miners.
If they are illegal, then honorable members, we need to move. Yes.
Thank you. One clarification from Minister, and I'm happy she's coming up. Can the Minister clarify to us what exactly made it so difficult for them to operationalize the law that is in place, and give us comfort that the amendments that you're going to make will make it easy for her to operationalize the law that you're about to amend?
Lob. Honorable Minister, first word for Lob.
Honorable Speaker, I think we need to get commitment from the Minister. For over 10 years, there's been no regulations. We don't know why. And yet this is a critical requirement, because that's one way of showing that as government you are committed to implementing these laws. Can we get commitment? Because we are here, we think that this is a good law. There's even no minority. I was consulting my colleague, the Shadow Minister for Gender, and she told me in the committee they were moving in sync, because these are matters that are for the good of everybody. So now that we are committed to bettering this law, can we get commitment from the Minister that as soon as, I don't know, you will commit to us, the regulations get to come? Thank you.
Thank you. Thank you. Honorable Minister. Hey, there was Mubende.
Thank you very much, Right Honorable Speaker, for the opportunity. I want to appreciate the committee for the report. But my concern, Right Honorable Speaker, as we plan to set a board that is going to cater for the operational safety and health at the top, we should also think about having these health and safety officers in the various workplaces. If we don't do that, then compliance will be very hard to all these that we are doing.
True.
Thank you.
Thank you.
Thank you, Right Honorable Speaker, colleagues. I will first answer the question about the challenges of the operationalization of the law. Colleagues, the law was focusing on the workplace with more than 20 workers only. The amendment to this makes the law apply for all workplaces. And the trainings are catered for under the law in section 13 of the old law. The issue of the board, Right Honorable Speaker, colleagues, we know very well that apart from before the rationalization, there are also those other boards that were supposed to take place to be established. But this particular one, Right Honorable Speaker, we did not have the money to operationalize the board, and the advisory is not standing board. So due to financial implications, we have not been able to have the board in place. The member asked about the question, the person who suffers from the injustice at the Workers' Compensation Act addresses this issue. The OSH is still centralized, especially for those who are asking about the district, why it's not decentralized to the district. The OSH is still decentralized, hence we are using this at the district. At the moment we are using our labor officers to handle most of the disputes affecting the staff of the local government. And also industry staff still apportion them to work with the labor officers at the district level. There was a question about the inspectors. We have limited numbers, that is true. Your Excellency, Right Honorable Speaker, the issue of the wage we know very well. We are not in position to have this, but if we are given the opportunity, we'll be able to have as many inspectors as possible, but we are able to work with the ones we are having so far, who are in the major industrial regions.
Right Honorable. Right Honorable.
The issue of the regulation. Honorable Minister, the law wanted a commitment on the issue of the regulation, that if we pass the law today, how fast can we have the regulation? Since do we have something we are trying to chew, Attorney General? Do we have something we are trying to chew in this law?
Right Honourable Speaker, on the issue of regulations, I fear that we are jumping the gun, but when it comes to discussing clause 118, on which our two sides have not agreed, our proposal was, among others, that a proposal for regulations can be sent to the sectoral committee to sieve it and make adjustments before it is passed, and that may require a particular time. So I was thinking that that particular area be discussed when we get to looking at clause 118 of the bill.
No. You know, Honorable Doug.
Incidentally, it is 118. Yes.
Doug.
Yes.
What we are saying, when we pass this law, do we expect regulations as soon as possible? Because it has been there.
Right Honourable Speaker, I do not want to commit on behalf of my colleague, but this is what I can say, because the Honourable Minister would have to work with the Attorney General's Minister establishing regulations, and whether he's required to table them in Parliament for approval or not.
Clause 118 of which law? This one?
Yes, the occupational safety.
We have not seen a clause 118. In the Parent Act, unless if you're talking about
I'm looking
the
at
parent.
the bill, 118 of the bill, which is 119 of the Act. The numbering changed. 119 of the Act, which is 118 of the bill.
Honorable Minister, we will give you 3 months to have the law in place. Because if you have a defect, you have a problem that you need to solve. Immediately we pass the law, it is assented, you go and work on the regulations.
Much obliged, Right Honourable Speaker.
Thank you. Lopez asking you, what have you committed to? That in how long you'll bring the regulations?
Right Honourable Speaker, we are committing that in 3 months we shall be having the regulation in place. Thank you.
Honorable members, if you agree with us, if we pass that regulation of on the legislative scrutiny, we are going to get members to make a follow-up on these regulations, and we'll even name the members tomorrow, so that we now see. I put a question that the Occupational Safety and Health Amendment Bill 2023 be read for the second time. Those in favor say, and the contrary nay. The ayes have it.
The Occupation Safety and Health Amendment Bill 2023, Bills Committee stage. Clause 1.
Chair.
Madam Chairperson, clause 1 is amended. A, by inserting immediately after paragraph C, the following. D, by inserting the following new definitions in the appropriate alphabetical order.
Can we come back to that after, in case on interpretation?
Okay.
We stand over clause 1 on interpretation.
Clause 2.
Clause 2, there is no amendment. I put a question.
Madam Chair, on this clause 2, which seeks to amend section 9, it reads that an inspector may, in consultation with the Director of Public Prosecution, prosecute, as the case may be, before a court any charge, information, complaint, or other proceedings arising under this act or in the discharge of his or her duty. My question with this is, the minister should clarify, what is the intention? Is the intention that before the inspector prosecutes must get permission from the DPP? What are they trying to cure here? Because this is about the prosecution powers. And then two, in the Mother Act, these powers were limited to prosecute before a magistrate's court. And then under clause 2, it was also provided that you could not challenge when a charge is brought at the instance of the inspector, you would not charge. So why are you doing away with that provision and now making it wide for the inspector first to now go to any other court, removing the limitation around the magistrate's court? But also the wordings here appear that this provision of the DPP can be dispensed with, because he's saying the inspector may, in consultation. So it leaves that discretion to the inspector.
Chair, we have not gotten exactly what he was mentioning. Maybe you can repeat it.
Attorney, did you understand? Where the law says that before the inspector prosecutes, he must get permission from the DPP. But then the question is, what qualification is the inspector? Does he have the powers to prosecute? I mean, yes, to prosecute. And how do you go and get the powers from DPP for you to be able? Because now when you read in the Parent Act, Section 3, who is an inspector, the appointment of inspectors, subject to any written law relating to the appointments of a person to the specific service, there shall be appointed commissioner and any other inspectors as may be necessary for the purpose of this act. So an inspector will be appointed for the purpose of this act. However, you're saying in the Parent Act, put Section 2, in the bill, powers of an inspector to prosecute.
Chair, under the Principal Act, Section 9, the inspectors have been given powers to prosecute. And under subsection 1, an inspector may prosecute or conduct, as the case may be, before a magistrate's court, any charge, information, complaint, or other proceedings arising under this act or in the discharge of his or her duty. And then under subsection 2, it says where prosecution is brought at the instance of an inspector or prosecution is conducted by an inspector, an objection to the competency of the inspector to give evidence as a witness in the prosecution shall not be sustained. Now, these two provisions are being dealt away with. They are replacing it with a new, as proposed in the bill under clause 9. But what they are introducing first is that they seem to be interested in giving the DPP a role which was not under the previous. But the way it is worded here, it does not cure that, because he's saying the inspector may in consultation, meaning there is no obligation to go to the DPP. I have a feeling that they wanted to cure that, because when criminal proceedings under the law, under Article 120, you know what the DPP does. It appears as if the intention was to bring the DPP, to take away the powers that may have been abused by the inspectors, so that the DPP has a role in the prosecution. But the way it is worded here means that the inspector can still actually prosecute without the DPP. That's the issue I wanted to raise first. Then secondly, is that in the Principal Act, the powers to the inspector was limited to prosecution in the magistrate's court. Now, when you do away with that, it's now you have given the inspector powers to prosecute in any court, including the court martial, by the way, if I may tell you. Yeah. So is the intention that now the inspector can actually charge me? Yeah. No, it's still a court, I believe. Is the intention now that when I've not managed my workplace very well and I've breached certain provision, the inspector can actually now say, I'm going to charge you in the court martial?
Madam Chair, if I have understood Honorable Dur well, in the first instance, the proviso intends to let the inspector consult with the DPP, because at any one time, you do not know the degree of the offense that arises. Some breaches may require the consent of the DPP. You know that there are offenses that cannot be tried without the consent of the DPP. So if you completely lock out the DPP and say that the inspector will prosecute without consulting the DPP, there will be a contradiction. I'm just stating my understanding of this. Now, the other one, permitting prosecution in any other court, also goes to say that there are some offenses, because courts have jurisdiction. There may be offenses that may not be triable in a particular court in which the inspector has jurisdiction and can only do so in a higher court with jurisdiction. But let's not mix that with the court martial, because the Supreme Court has made a declaration to that.
You know, here it was only limiting to magistrates' court. It was limiting to magistrates' court. Yes, Counsel? Sorry, Honorable Minister.
What Honorable Speaker, even Counsel is actually, that is an earned reference. I trained to get to be, I'm a Counsel actually, yeah. But just to support the Attorney General, I wondered what Honorable Odur wants. The law, if it is drafted in such a way that gives latitude, the word may, unless you think that that discretion will be abused, which you could state it. But a word may, in consultation, what would be the role of the DPP? Would it be the one to sanction? You give the prosecutor, the inspector, the opportunity to determine, as what the Attorney General said, to determine the fora, the jurisdiction, the offenses, and also, Honorable Odur, there would be no any circumstance that inspector envisaged in this bill would have reference to the court's martial, because the offenses under court's martial are prescribed and they are not relating to workplace offenses.
Honorable members, the justification that has been given, you've had the justification. Honorable Duru, are you satisfied? At least one thing you're sure that it will not be court-martial, but it will be a competent court. And we are trying not to limit really to magistrates' court because of the gravity of the matter may be higher than what magistrates' court may handle.
Chair, one of the observations by the justices of the Supreme Court is that when we come here, instead of clarifying certain situations, we leave it to be open. And in that judgment, court-martial has been recognized as a court. It is the jurisdiction that is in question. They didn't say it is not. So when you leave the word court here, and court-martial is a court, it can, and I wanted that to be on the record. Secondly, if the Attorney General could actually tell us which offenses
assuming
are
we
here.
say a competent court, because that would depend on the what? You just put a competent court before a competent court.
Chair, I didn't want to go into that argument because that court also in some cases, but the point I wanted to raise is that if the intention here, for me, if you read carefully Article 120, my thinking and my interpretation is that no criminal proceedings, including even those ones in the court-martial, can actually be started without the DPP. So here, if the intention is that you want to involve the DPP, the word may, I am uncomfortable with that. Because the DPP is the public guarantor of abuse by the executive. The DPP, that's the role. The Directorate of Public Prosecution was put there and said
So
you shall be independent so that in case the executive has some excess and wants to abuse, the DPP is supposed to guarantee that by saying stop, don't charge or charge, something like that.
Do you have an issue with the shall?
Right, Honorable. I like the eloquence of my colleague, but allow me say this. If you read the OSH, the bill as it is intended to create a mechanism to oversee and enforce safety within the health system. In essence, it's creating a kind of pseudo-disciplinary committee. I do not want to be quoted on those particular words, but I'm just using figuratively speaking. A court within a health system, okay? Meaning that there are certain things that can be handled within that system, within that health setup, without necessarily referring them to the DPP. That's why they are saying there are those that may be exaggerated and may require the consent or consultation with the DPP. That's why we should use may and not shall.
Thank you. Chair, this parliament has made pieces of legislation where we have given prosecutory powers to different individuals without even necessarily involving the DPP. We have done so, you know, under the Wildlife Act and other pieces of legislation. I'm not so sure, Learned Attorney General, what you want to achieve here. I'm not so sure. Either you give full prosecutory powers to inspectors, the way we've done with other pieces of legislation, or...
Honorable, let's not go generic. Let's look at what is specific here. You read what the law is saying.
Yes.
No, you read it so that we
Right, Honourable Speaker.
Clause 2.
The clause 2 says, powers of the inspector to prosecute. An inspector may, in consultation with the Director of Public Prosecutions, prosecute as the case may be before a court any charge, information, complaint, or other proceeding. And Right Honourable Speaker,
arising under the Act
yes,
or in discharge
of his or her duty. Yes.
As the case may
yes.
be.
And Right Honourable Speaker, Chair, what I am asking the Attorney General to clarify and help is what we want to achieve here. Because this House has set a precedent. We either give full prosecutory powers to inspectors or require that they cannot prosecute before consultation with the DPP. Because this is neither here nor there. And that's the problem. So you just clarify what do we want to achieve? Because this provision here can be problematic. In fact, the discretion we are talking about is one which is subject to abuse. On what basis, for example, would the inspector use to consult the DPP? What would be the basis? That now, in this particular case, let me consult the DPP. Yeah. In this one, let me not consult the DPP. That's why we must be very clear. Either we give them full prosecutory powers, or the way we've done with the other pieces of legislation, require that DPP sanctions or consults. And we move.
Yes.
Right Honourable Speaker, I do not like insisting on matters a lot, but on this one, Right Honourable Speaker, I'm calling upon my colleagues to understand my position. We cannot anticipate the kind of offences to be committed. For purposes of clarity, we can have certain aspects put in the regulations. Certain perimeters can be put in the regulations. Let me give you an example. Let me use an example, a hypothetical one. A doctor who deliberately kills patients. Yes, and injects them. I'm giving an example. Are you going to say you leave that to the inspector to prosecute? It does not require the DPP. So that's why we are saying, no, the offenses are light and heavy based on a particular case. That's why we should allow the regulations to stipulate which kind of offenses will require the DPP and which kind of offenses can be prosecuted.
Honourable Attorney General. Honourable Attorney General. They said an inspector may, in consultation with the Director of Public Prosecution, prosecute as the case may be. As the case may be. That is still discretionary. Even if we put shall, it will still remain as the case may be. What is hard? Don't we have trust in our DPP? Yes, Council.
Right, Honourable Chair. I think with the text being projected up, there are key issues there. The inspector, and then the provision for consultation with the DPP. And we all know the constitutional role of the DPP in relation to criminal prosecution. And then, as the case may be. As the case may be also offers that, you know, that's as case-by-case basis. It's not that the inspector will consult in all matters and at all times. This is my understanding. And looking at that the provision as proposed there, I think it would be good that I had provoked Jonathan, Honorable, is also a bus owner, he runs to tell us what would be the subject of his concern with the use of may. But in all fairness, this is a better way to frame that, because you get an inspector, you don't want that inspector to overstep the mandate to prosecute on criminal matters. You don't want a prosecutor to overstep the mandate in criminal,
Honorable
criminal
both,
prosecution.
you will start cherry picking on what he thinks should be, he should consult.
And unless this house feels that is not good, then you use the word shall. But if it is fair, you use may.
Yes, workers, let me first hear from workers. Chair University.
Thanks very much, Madam Chair. I listened to my colleague and the Attorney General, but I want to give you a background, and that's why I'm coming in for SHA. I had stated in coming in for this. When it comes to the regulations which they are referring to that they are bringing very soon, experience has shown us, including NSSF, Minister of Gender has never brought regulations. Let us tie it now and finalize it.
We are not in a market. What is your position, Chair?
Madam Chair, when we were interacting with the movers of the bill, the reason they brought this out is that on a number of occasions they have failed to win those cases because sometimes they are wrongly presented to the courts. That's why they now decided to amend to bring in so that they are able to consult with the DPP so that the cases...
So we must. Yeah.
So I agree we can go with shall.
Thank you, thank you.
Madam Chair, that now is more clear, and I would now propose that instead of the use consultation, we say consent, because that's what they do, consent of the DPP, not consultation, to cure what they are saying. Yes.
Chair.
Madam Chair, consent will almost stand the whole meeting. There are cases where, for example, provision of drinking water at a workplace is a simple issue which the inspector can handle. But there are those grave cases like where you are negligent, employers negligent, and people are crushed by the machine. So they are different. So when you say consent, it means every time the inspector must seek for the consent. So I think shall would be okay.
Consultation. Consultation. Let's
Honorable Speaker.
Asman, why are you making noise?
Looks like I'm defeated on this. I will begrudgingly concede to shall.
Shall, yes.
I will begrudgingly concede to shall and consent.
And what?
And consent.
Okay. AG. I put a question that clause 2 be amended as proposed by Honorable Oduro and further amended by Honorable Deputy AG. Those in favor say and the contrary nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it. Ekanya, you have crossed.
New clause.
New clause.
Insertion of a new clause after clause 2. The bill is amended by inserting immediately after clause 2 the following new clauses. Amendment of Section 10 of the Principal Act. Section 10 of the Principal Act is amended by deleting subsection 3. Insertion of Section 10A in the Principal Act. The Principal Act is amended by inserting immediately after Section 10 the following. 10A, functions of the board. The functions of the board are: A, to advise the minister on matters concerning occupational safety and health. B, to advise the minister on formulation and implementation of policies, plans, programs in occupational safety and health. C, to set standards, guidelines of practice for safety and health practitioners. And D, to perform any other function as may be necessary for the purposes of this act. Justification. Section 10.3 has been incorporated under the proposed Section 10A, which provides for the functions of the board to standardize and regulate the work of safety and health practitioners.
Sir?
Right Honourable Speaker, I take note of and concede with new amendments proposed after clause 2 to stipulate functions of the OSH board to include regulations of the safety and health practitioners.
AG?
I concede.
I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
There is no amendment. You have an amendment on 3?
Yes. Right Honourable Speaker, clause 3. The bill seeks to repeal the word as far as reasonably practical. And I don't see its danger. If I may read, the parent law 13, it is the responsibility of the employer, A, to take as far as is reasonably practicable all measures for the protection of his employees or her workers and the general public from the dangerous aspects of the employer's understanding. I don't see the danger of this as far as reasonably practical. I don't see its danger. Because you take measures as far as it's reasonably practical.
But we don't want compromise on hazards. We don't really.
Because the way it stands now in the law, it gives latitude to the courts to determine what is practical in the circumstance and what is not practicable. But when we remove it, even what might not have been foreseen, every other circumstance would be blamed onto the employer. For me, I really don't see a problem with it the way it stands.
The employer must ensure safety. Must ensure safety. For instance, if you're in a petrol station and there is fuel that has spilled over, and you say, that's not my responsibility, and yet that can cause a problem. So you must ensure that there is safety here. You get it, eh? No, that's right.
Maybe, Chair, you would hear from the Attorney General. Do we
Yes,
presuppose
Attorney
that the employer should have been a demigod that must see everything? Because there are situations that might not be foreseen.
Right, Honourable
hazards,
Speaker.
Honourable Aisha, hazards.
Right, Honourable Speaker. The reason they are removing the word reasonable, practicable, is to create strict liability on the employer.
Yes.
Because the word reasonably practicable gives you leeway to say, I could not afford or I could not manage. So they are squeezing you, no excuse. Yes.
I put a question that clause 3 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Madam Chairperson, insertion of a new clause after clause 4. The bill is amended by inserting immediately after clause 4 the following. Amendment of section 15 of the Principal Act. Section 15 of the Principal Act is amended by substituting for the words safety representative. Wherever the words appear, the phrase safety and health representative. Justification to include an aspect of health in the reference to the representatives of safety and health at workplaces who are currently referred to as safety representatives.
AG?
I concede to this.
Minister?
Right Honourable, we concede.
Thank you. I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 5.
Chair?
Clause 5 is amended. Amendment of section 16 of the Principal Act. Clause 5 is amended A by inserting immediately before paragraph A the following. In the head note, by inserting immediately after the word safety, the words and health. B, in paragraph A, in the proposed subsection 1, by inserting immediately after the word safety, the words and health. C, by substituting for the paragraph B the following. B, by substituting for section 2 the following. 2, the safety and health representative shall represent employees on the safety and health committee. D, by inserting immediately after paragraph B the following. C, in subsection 3, by substituting the words safety committee, the words safety and health committee. Justification to include the aspect of health in reference to the committee of safety and health at workplaces, which is currently referred to as safety committee.
AG?
Insertion of the new clause after clause 5. The bill is amended by inserting immediately after clause 5 the following clauses. Insertion of section...
AG?
Right Honourable, we are in agreement.
That's a consequential. Yes.
Right Honourable, we concede.
I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Madam Chairperson, insertion of clauses after clause 5. The bill is amended by inserting immediately after clause 5 the following clauses. Insertion of section 16A in the Principal Act. The Principal Act is amended by inserting immediately after section 16 the following. 16A, registration and licensing of safety and health practitioners. The minister shall make regulations to provide for the registration and licensing of safety and health practitioners. 2, a person shall not conduct a safety and health risk assessment, safety and health audit, or any other assessments or audit required under this act unless the person is registered and licensed by the commissioner as a safety and health practitioner in accordance with this act. 3, a person who contravenes subsection 2 commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points or imprisonment for a term not exceeding 2 years, or both.
Honorable Minister.
Right, Honorable Speaker, I take note of and concede with the new amendment proposed on clause 5 to include the aspect of health in addition to the safety aspect.
Thank you. AJ.
We are in agreement, right, Honorable?
I put a question. Was this a continuation of that? The replacement? It's a new insertion.
Madam Chair, this is a continuation, replacement of Section 21 of the Principal Act. Section 21 of the Principal Act is substituted for the following. 21, measures to monitor health of workers. 1, an employer shall put in place measures for
Yes. Continue. Have you finished?
Shall put in place measures for A, monitoring the health of workers, B, management of workers exposed or likely to be exposed to occupational hazards, and C, prevention of occurrence of occupational diseases and disease outbreaks. 2, for the purpose of this subsection 1, an employer shall have the duty to A, prepare and submit to the Commissioner for approval a health surveillance plan for the employer's workplace. B, inform a worker of any health hazards involved in his or her work and the health arrangements that have been put in place to protect the worker. C, carry out pre-assignment medical examination on a worker where the assignment exposes the worker to danger. D, carry out medical examination upon termination of the assignment or employment of a worker where the assignment or employment exposed the worker to danger. E, carry out periodical medical examination on a worker based on findings from the medical examination of a worker on the recommendations of the Safety and Health Committee. And F, put in place occupational health services. 3, for avoidance of doubt, an employer shall bear the cost of the medical examinations required to be performed under this section. For purposes of this section, health surveillance plan means a plan put in place by the employer to monitor and assess the health of workers who may be exposed to hazards in the course of employment. Mental health services include assessment, diagnosis, treatment, care, counseling, or any intervention provided to the worker to promote emotional, psychological, and cognitive well-being of the worker. And occupational health services include disease outbreak management, wellness programs, rehabilitation of sick workers, mental health services, vaccination programs, promotional health services, and other services prescribed. Under this health surveillance plan, safety and health risk assessment, report, and any national health guidelines. Notification of occupational accident, disease, and incident. 1, An employer shall keep and maintain a record of an occupational accident, occupational diseases, outbreak, and incidents. 2. Where an occupational accident or occupational disease outbreak occurs, the employer shall notify the commissioner in a manner and within the time prescribed by regulations made under this Act. Justification: to ensure regulation of and standardization for safety and health practitioners, there is a need to carry out occupational safety, occupational health and surveillance of the risks arising at a workplace and put in place measures to safeguard the health and safety of workers. There is a rise in risk related to lifestyle at the workplace, for instance, long hours of sitting and mental illness. So there is a need to have occupational health services to monitor the health of workers, to ensure that the commissioner is able to access information on occupational diseases and occupational accident for action.
I would love to hear from Attorney General, but also the Chair and the Minister. What measures, what sanctions do we have prescribed in this amendment to cater for those employers who do not comply with these enlisted demands? Are they strong enough? If they are there within, maybe you recite them so that we're able to know that they can stand and help us to make sure that people do what they are supposed to do. For instance, I would be happy if somebody is not complying, we revoke their license if somebody is operating. What measures? What sanctions?
Check section 102. Yes. Yes, Chut.
I just wanted to propose an amendment on registration and licensing, saying by the commissioner. I would have proposed that should have been the Occupational Health and Safety Board. Ideally, you cannot be licensed by an individual. There should be a body that is overseeing that practitioner. And we have the Occupational Health and Safety Board that is mentioned here. Secondly,
should be a minister.
Yes, but in this act, there is the Occupational Health and Safety Board. And that is what I thought should handle, not the commissioner. If the board is not there, then it can be the minister. But in this case here, there's a Occupational Health and Safety Board. The second issue, I want to also propose another amendment. We've provided that it will be the duty of the employer to inform the worker of the hazards at their workplace and the preventive measures to address them. However, this provision does not give a timeline, whether you're supposed to inform 1 month after employment, 2 months. So my proposal is that we should add a clause on it that it should be, this information should be provided within the prescribed time by the regulations, so that it is not just open-ended for the employer to inform at whatever time they wish to. Related to that also is medical examination after termination. There is no prescribed timeline. And I'm proposing again that we should put a clause within the period prescribed by the regulations. The standard practice actually is normally within 30 days, but you can have the period prescribed by the regulations. So I just wanted to propose those amendments within it.
AJ?
Chair, before the AG comes, the chairperson presented two. One, the insertion of a new clause, which we have not processed, and the amendments coming like from the Honorable Pierre Chut. I thought that that issue should be dealt with standalone.
What we are looking at is the new clause.
Yes, but she also went ahead and also proposed an amendment purportedly under a new clause, but she's amending section 21. And that's why also some ideas have come from Achuti. So maybe we first deal with the new clause before we go to the amendment. And the record should correct that that's not a new insertion as they had proposed. If they intend to amend section 21, it should be reading amendment of section 21.
The actual
Not-
saying replacement of section 21
Yeah.
of the Principal Act.
Yes, which is an amendment. It can't be a new insertion.
So the other insertion, these are 2 in 1. Now, can we first split and first have the insertion, which was S16A, which you accepted already, and then we go to part B. I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. Minister, 21. Replacement of 21.
Right Honorable, we concede with the amendments proposed after the clause 5 on the registration and licensing of the safety and health practitioners.
Right Honorable, I'm requesting for purposes of clarity that Achuti repeats his concerns, so as I see how it fits in here.
Chut.
Yeah, I was on 2B and 2D. It is providing that the employer has to inform the worker of any health hazards involved in his or her work and the health arrangements that have been put in place to protect the worker. My issue is that there is no timeline provided. And so I was proposing that we would add a clause saying that within the prescribed times, within the times prescribed by the regulations, so that there's a time period. The same also applies to D, which talks about carrying out a medical...
Are we together there?
Yes, the second is also applying to, which is D, which is talking about medical examination after termination. And what we're trying to propose, it also doesn't give a timeline. So we're saying we also indicate that within the period prescribed by the regulations, so that after termination, there is a maximum period within which that medical examination should be done. Chair, we had jumped over what I had proposed, the registration and licensing by the commissioner. I thought we needed to discuss that, whether it should be the commissioner, the minister, or the board. Thank you.
Yes.
In response to what Honorable Achuti is proposing, my view would be that we simply say before commencement of the job, before you do the work, you should be told what to expect. So instead of referring again to regulations which may not come, because these days I don't trust most of the ministers when it comes to regulations. Maybe the minister here is good, but some ministers are suspicious.
Thank you. You see, sometimes legislation is not impregnated with many issues. And the reason why Parliament empowers ministers to make subsidiary legislation is to cater for some of these exigencies. And you would do us a lot of good if you really took the wise counsel to have regulations in place. The reason why, for example, the Honorable Chota and others are concerned about this, ideally, matters to do with the timelines are issues that can be adequately covered in regulations. But because we don't have a culture as a front bench of having regulations, it creates a very big problem. Now, this particular issue, for example, will keep changing. Circumstances and situations at workplaces keep changing. That legislating on time, for example, on this matter, which is a duty, the way it is worded becomes extremely difficult. So I think, Minister, if you really made a commitment on the issue of regulations, these are matters that can be effectively and comprehensively covered under regulations because they are circumstantial. The way this clause is worded is creating a duty on the employer, an obligation on the employer. So even it also follows that when it comes to certain timelines, circumstances may change, where you may require that flexibility is exercised through regulations.
Chair.
But Chair,
Yes.
I'm worried for one thing. If we refer to regulations, somebody is employing somebody, and the minister has not made regulations, and we are referring to regulations which are non-existent.
Non-existent.
Do you see the gap? It is so huge, and we can't speak about it. So, right about Speaker and Chair, the best thing we can do is to ask that you, the employer, you do your part before the person starts with employment. Before the person starts their work, tell them what to expect. Then it will be easy. For me, I would think that is rather direct. And the Attorney General, being a good drafter, can draft a good piece to fit that particular requirement.
Right, Honorable Chair, what Honorable Silos is saying is a bit not very practical because circumstances keep on changing. Suppose a new machinery is bought, there are new hazards that come in. So we cannot simply make it a duty before commencement of job because new circumstances will arise during the employment time that might need the employer to update the employees on the hazards at the workplace. So I agree with Honorable Basarira that the regulations will take care of that. The regulations would explain how often and under what circumstances would the employer keep updating his staff of the new hazards that would be at the workplace.
You know, when you look at clause 21 on the Parent Act, look at clause 21 on the Parent Act. Section 21, employer to supervise the health of workers. It talks about the pre-assignment medical examination of workers before assignment of specific tasks which may involve danger to their health or that of others, then periodic medical examination of workers during employment, then the biological monitoring or investigation which may be necessary to control the degree of exposure and supervise the state of health of workers. I don't see why it is even being replaced. Why are we replacing what was better? This was much better.
Right, Honorable. I do not think this is entirely replacing the old section. It is an amendment.
Read the heading. Replacement of section 21 of the Principal Act.
Yes, and I think some time back you realized that this was a mistake. The word replacement was a mistake. It should have been amendment of section 21. Not replacement.
Section 21 of the Principal Act is substituted by the following. Substituted. That's what the committee is saying, Honorable Doug. So, can we have this corrected? Is it a substitution, a replacement, or an amendment?
Right, Honorable. My understanding of this is an amendment.
Chair, explain.
Madam Chairperson, as a committee, we expanded on section 21. That's why we said we are replacing it, because we expanded and gave more obligations to the employers in protecting the health of workers.
So you're substituting what was in the Parent Act, or you're amending it? I want it on record. Yes, no.
Right Honorable, I think the intention is to expand the obligations of the employer in this case. So maybe the draftsperson would help us. This is not a replacement, it is an amendment. It's an addition to what exists in the parent law. Taking more responsibility
So what has
on
been
the employer.
Chair, just tell me what you've added on what was existing and where.